Authoritative news analysis platform, and here on Newsfile, we put Ghana first. My guest, Clara Berry Kasati, is law lecturer, University of Ghana, School of Law, and is in private practice, also with the CDD Ghana. Roxanne Nelson Dafiamapo is Majority Chief Whip, and MP Sandai. Dennis Miracle Sabwaji is Director of Communications, the Bamia Campaign, and Dr. Theo Echampong is Political Risk Analyst and Economist. Now, let's get to the next issues that we are canvassing for you. The Chief Justice is in the High Court saying that you removed me as Chief Justice using a procedure for removal for a Chief Justice. You didn't trigger the procedure for removal of a Justice of the Superior Court. I am first a Justice of the Superior Court before I am a Chief Justice. So I must remain as a Justice of the Court. What do you say? And this show is brought to you by Candace Panshaw, Bank of Africa, strongest group and closest partner, MTN everywhere you go. Ashasi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 plus years. My Way Insurance. Dial *165# on MTN to join My Way today. Syntax Tank is strong, it's tough. Activa International Insurance. Our clients are Pashing International Facilities Management Association. They are proud to be associated with your most authoritative news analysis platform, Newsfile. Safari Valley Eco Park, bringing you closer to nature. So on that matter, let me begin with Roxanne Nelson Dafiamapo. But before I do that, I think that I have the obligation to clarify one issue that came up. Two suits were brought to the Supreme Court in 2015 by the Ghana Bar Association and Richard Dela Sky. And they were asking the question whether advice is binding on the president. The Supreme Court held that advice, when it is being sought for by the president in certain circumstances, is not binding. When the advice is for a consultative process, it's not binding, like seeking to appoint the EC chair, which led to Richard Sky's rate, seeking to appoint judges, which led to the Ghana Bar Association's rates. That kind of advice is not binding. But the kind of advice as we see in Article 31, where the president is asked to act in accordance with the advice of the Council of State, that kind of advice is binding. Thank you. Yes, the CJ.
Yes, the CJ is in court, praying the court that her excision from the judiciary, as it were, as Chief Justice Justice of the Superior Court, should be looked at again, because constitutionally she's entitled to remain as a judge, even though the procedure was or the processes that led to her removal was in respect of her position as CJ. That is untenable. That is not the constitutional architecture that we have. Our constitutional architecture is the effect that the CJ sits in a composite capacity as a judge as well as head of the judiciary.
Dual roles.
And therefore, where your activities of your administrative functions have been called into question and leading to a petition resulting in your removal, it also affects your role as the judge, because it goes to the propriety of being eligible to sit or to be fit for purpose as a judge, judge. And this is not the first time this matter has come before the courts or engaged the courts in these issues. 30 years ago, the Ghana Bar went to court to, as it were, get Justice Aban removed. And in the course of the preliminary objection raised by the then Attorney General, the court upheld the preliminary view, but in the course of writing the ruling, the reasoning behind the ruling, people like Pega made this very important dictum that should guide us. He was of the opinion that the processes that was before them, if it succeeds, it will lead to the removal of the Chief Justice, not as mere Chief Justice, but also as a judge of the Supreme Court. Then again, in the matter of Ajechu, Justice Dateba went to town. He actually exploded.
So you refer to a first one 30 years ago.
Yes.
You refer to a second one, which
in
was
fact,
in
10 years after.
2006.
2005, 2006. 10 years after, Ajechu went to court. And to challenge the contents of the petition linked, that's Bright Akwete's petition. Again, the court took the trouble to explain that if the processes succeed, it will lead to the removal of the Chief Justice as well as a judge of the Supreme Court. Then finally, CJ's own case, her own case, one of the cases she took to court a couple of months ago, Justice Amadou Tanko, he reasoned this way, and this on page 26 of 32 of the ruling, of the judgment of the court. He said, as part of the conclusions, the above observations provoked by paragraph 12 of the applicant's affidavit aside, I need hardly say that I arrive at the conclusion that this application must fail without relish, mindful of the fact that the applicant, the Honorable Lady Chief Justice of the Republic, is going through a process that may define her career on the bench as Chief Justice and as a judge one way or the other. So this is a beaten path. It is settled. There's nothing to be determined otherwise. Yes, it's right. You see, because the propriety of your conduct as a superior court judge, which may lead to your removal as a basis of a petition questioning same, is the same as the propriety for the removal of a court of appeal judge, of a high court judge.
But the argument she makes is that in Article 146, if you want to remove a superior court judge, you use Article 146 Clause 4. But if you want to remove a Chief Justice, you use Article 146 Clause 6. So why do you use 146 Clause 6 process to remove her and then come to argue that, and you issue a warrant under the hand of the president, and you issue a statement also signed by Dr. Callistus Mahama, and you say you have been removed as Chief Justice and a judge?
Yes, because
when you use only one procedure, not the other procedure.
Because the procedure in 1464 is in respect of a superior court judge, which could be a high court judge. That was not the terms of the petition that came before the president. It was the petition against the removal of the CJ. And you can't be a CJ without necessarily first being a superior court judge. In this case, a Supreme Court judge. And Article 128(1) is very clear. The Supreme Court shall consist of the Chief Justice and no less than 9 other judges of the Supreme Court. You are the chief of all the judges.
The Chief Justice is actually a judge in all the courts.
In all the courts. That's our constitutional structure. So you are actually the chief of all the judges. So where your conduct has been called into question, that leads to your removal as the head of the judiciary. There's no way you should survive.
The Chief Justice is an administrative role.
No. The Chief Justice is not merely, that's only one part. The other part is that you're also a Supreme Court judge. You actually empanel the court and you sit.
That's an administrative role.
Yes. But you hear decisions. You deliver judgments. So you can't say that where your functions as an administrative arrowhead is called into question, has been determined, pronounced upon, as being a basis for your removal, we should not allow you to sit as a judge. Because it's the same grounds. In fact, if you take the code of conduct for judges in this country, a breach of one of this code to lead to the removal of you as a CJ. just a breach of this one code.
Yeah, so the argument is not about the CJ.
The argument is about the fact that she's trying to decouple herself from her role as a CJ.
Is it true that she performs dual functions?
It is true. That is the Constitution.
Okay.
The Constitution says to be a CJ,
Clara,
you perform dual functions. You sit as a judge.
Clara, help us. Do you subscribe to that kind of argument that we go to Kpegan's pronouncements, as he said some 30 years ago, then we go to Ejechum 2006, then we come to Databa Modibo Okran, rather read Modibo Okran, and so on. Yes.
For me, I would go back to the constitutional architecture.
Okay.
It provides the grounds for removal, whether as CJ or as Supreme Court judge.
Separately?
No, the grounds are the same for both.
Okay.
The grounds are stated misbehavior or incompetence or ground of inability to perform your office. It is the procedure that is different. Because if it was a Supreme Court judge, you would have to refer the petition to the CJ to make a prima facie case. But if it is the CJ, of course, then it's we've just seen how that process has
President
followed.
And Council of State.
Exactly. So the second thing is that if the person is a CJ, and you even actually bring a petition not to remove them as a Supreme Court judge, you can't go and refer it back to the CJ for the CJ to make a decision whether he or she themselves have. So the truth is, even if you were making the claim against the person as a certain Supreme Court judge, you would, and the person is a CJ, you would still have to use a procedure for CJ. Now, for me, I would differentiate personally. Now, this one is my personal. So that's the constitutional architecture.
Sorry, say that again. Did you say if you are seeking to remove a Supreme Court judge, the procedure to be used will be that for the CJ?
No.
Okay.
I'm saying that if you brought a petition to remove the CJ in her capacity as a Supreme Court judge, you would still have to use the procedure for CJ because she's CJ.
All right.
You get what I'm. She's CJ, so you can't refer it back to herself to make a prima facie case and all of that. So I think for me, I wouldn't split heads over the grounds because they are the same, or the procedure because once the person is CJ, that's the only procedure you can use, whether you are removing them as Supreme Court judge or CJ. What I would differentiate, and now this is my personal view, is that I would differentiate between whether it was it was related to the administrative role or it was under the grounds. Because if it is under the grounds, it's really splitting heads to say it. For me personally, for me, I've always, one of the things I believe in, which I've been talking about, is rules of procedure for Article 146, not just only for the CJ, but rules of procedure for all those who come under Article 146 removal, just for fairness and transparency and clarity. So at least everybody knows the procedure that they are going to follow, and then it takes place. Since we don't have time, that is what.
Rules of procedure have been asked for over the years, but they have not been made.
Yeah, unfortunately. And I don't have the power to make them. But yes, I would advocate that they be made.
At pains in a Ejechum to say that it should be done and done immediately.
It's important.
And it's still not done.
We have rules of procedure for everything. So we have rules of procedure for the district court, we have rules of procedure for the high court, we have rules of procedure for the court of appeal, rules of procedure for the Supreme Court. Why not rules of procedure for Article 146 removals?
Over the years, they have been using...
We have rules of procedure for disciplinary hearing of the GLC.
Yes. Right. I think the rules of procedure...
Over the years, they will adopt the CI 47. That's not good. No,
let's just make rules of... let's just do the rules of procedure for Article 146 so that we know, anybody coming under it, we know how the rules change. Why it is also important to have rules is that what the CJ is complaining about, that I didn't get A, B, C, D. So if there's a problem with the rules, we can amend them.
Okay.
So at least we can grow whilst we have rules.
Right. Mama Yarga says they are going to make rules now. Let's see what difference those rules will bring anyway. Dennis, do you share a different view? The Constitution says that to become a justice of the Supreme Court or the Superior Court, or even a judge, you must be a person of high moral character and proving integrity. High moral character and proving integrity. And to lose that job, you must have been found to have conducted yourself, stated misbehavior, or incompetence, or infirmity of body or mind, and so on and so forth.
So I think that when it comes to issues like this, nobody should assume any role or responsibility that the law doesn't give you. I believe that we need to be a bit more fair to the Chief Justice. At this point, after whatever the government wanted to do, they've done, I think it's time for us to calm down and begin to give her some hearing. I have always had a problem with the basis for a removal and all the things they went through. I mean, first of all, I think that there is no audit report from any auditor general indicating the primary, allegation they used against her. And I don't think our laws allow any other committee or body to determine these things other than the auditor general. I am very sure that when this government eventually leaves office and this woman gets an opportunity to go through this process again, we'll see a lot of gaps. But it's okay. For now,
it's not only the financial impropriety
most of them,
that was used.
Most of them. I mean, for now,
according to the outcome and the letter that communicated her removal,
I agree.
She was also found.
As it stands now, nobody has even seen the report. Okay. Even she herself has not received a copy of the report from the president. The only thing she's received is a letter from the secretary indicating that she's been removed.
That's precedent.
I'm just saying that as of now, she hasn't received it. So we don't even know. We don't even know in proper terms the basis for a removal other than what the president has stated. That's what I'm saying. When this government eventually leaves in 2029, we will know the details. That notwithstanding, I just want to ask. I know if I'm a judge, I'm supposed to live above reproach. So I am caught for stealing. And I'm dealt with according to stealing, which is misbehavior. The law doesn't say that automatically I cease to be a judge. The law says that I must be taken through a certain process and then I'll be removed as a judge. Is that the case? Then if that is the case, there's a process to remove the Chief Justice, which you've gone through it with me. There's a process to remove a judge of the Supreme Court. It is only fair that and proper that you take the basis and whatever ruling, whatever evidence here, and take it through the process of removing a Supreme Court judge. And that is what I think the lady is looking for, basically. At this point, what we are doing is that we are saying that because we found you guilty on one thing, automatically you won't qualify for this. But here we are, and we are all clear in our minds that the person is saying, I wasn't even given a fair trial through this committee. So if she goes through the process of removal of a Supreme Court judge, she may adduce further evidence to, clear herself for certain things that have been made against her. But to say that because the processes of a removal of a Chief Justice have been seen through, and for that reason she has been removed, automatically she ceases to be a judge, is to say that if a judge is found guilty on a crime, automatically that judge ceases to be a judge. When the Constitution or the law itself has given a process that you should take a judge through before they are removed.
Have you tried to look at what the difference is about the procedure for removing a Superior Court judge and the procedure for removing a Chief Justice?
The simplest, one of the basic differences I've realized is that if you're going to remove a Supreme Court judge, the Chief Justice handles that, right?
What do you mean by handles that?
It goes to the Chief Justice. Now, if you look at the committee,
it goes to the President.
Of course, and the Chief Justice.
The petition will go to the President. The President will send it to the Chief Justice.
Yes.
Then the Chief Justice will determine whether there's a case to answer or not.
In this case, the committee, actually the membership of the committee, as to whether they have the jurisdiction to remove a judge of a Supreme Court, it's another question. So the fact that the membership of that committee, of course, the membership of that committee, do they have proper jurisdiction to remove a judge of the Supreme Court?
Or the committee or the committee?
No. The committee. The committee
that was set up.
That committee has jurisdiction over determining the fate of a Chief Justice. But do they have the jurisdiction over determining the fate of a Supreme Court judge? If they don't, then all you have to do is take whatever it is that they have done, which is now evidence of whatever crime the Chief Justice may have caused, and take her through the process of removing her as a Supreme Court judge and allow her to defend herself.
Okay,
that is the law.
So the Constitution says, the Constitution says, as a Supreme Court judge, or as a Superior Court judge, or as a judge, the only time you may be removed is that you have been found on these grounds, stated misbehavior, incompetence, or inability to perform the functions of your office arising from infirmity of body or mind. Are you saying that if, in this case, having been found guilty of stated misbehavior over financial impropriety, over attempt to appoint extra Supreme Court judges, etc., it can only remove you as a Chief Justice, but not as a Supreme Court judge, regardless that the verdict is that you have been found guilty of stated misbehavior?
That is why I said that. The 1462 is clear. It says that may only be removed by the procedure.
That's
so
1461.
No, 2. I'm referring to 1462.
Okay.
Yes, I'm referring to 1462. May be removed
in accordance
by the procedure. And if you may, I can even read it. It's 146.
A justice of the Superior Court of Judicature or a chairman of a regional tribunal may
only be removed in accordance with the procedure specified in this article. The procedures are not the same. The procedures for removing the Chief Justice is not the same as the procedure for removing a judge of the Superior Court.
And the only difference, as you have indicated, first and foremost, is that...
Like, I think that is primary. That, for example, on this committee were 2 other Superior Court judges. When you are removing a Chief Justice, would these 2 other Superior Court judges be there? Would Domelevo be there?
Okay, so let's look at it. If you are removing a Superior Court judge, clause 4, where the Chief Justice decides that there is a prima facie case, he shall set up a committee comprising of 3 justices of the Supreme Court, or chairman of the regional tribunals, or both.
Which one are you reading, please?
Clause 4.
Okay.
1464.
Appointed by the Judicial Council and 2 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers, and who shall be appointed by the Chief Justice on the advice of the Council of State.
Yes.
So the first difference is that to remove a justice of the Superior Court, Chief Justice will make a prima facie case.
Yes.
And after that, the Chief Justice, together with the Judicial Council, will appoint the members who will form the panel. Then clause 6, where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. So the appointment of the committee to do the process is done by the President with the Council of State.
For Chief Justice
and
removal.
prima facie is also done by the President with the
for
Council
Chief
of
Justice
State.
removal.
This is the difference.
For Chief Justice removal.
That's right.
But for the removal of a judge of the Supreme Court, the committee should be set up by the Chief Justice, not the President.
With the Judicial Council.
Yes, not the President.
Right.
Secondly, I made a fundamental point, and I think that's what we should all use our mind to. Let's say I'm a Supreme Court judge, and then I'm found to be beating my wife. And so my wife takes me to Dofsu, and Dofsu takes me through all processes, and I'm found to be domestic violence. It doesn't automatically disarm me from being a judge of the Supreme Court.
That's correct.
But somebody can, based on that ruling, now petition the Chief Justice and say, this judge is a woman,
the President.
The President, and say, this judge is a woman beater. I don't know why you allow a woman beater to sit as a judge in this country. The President may now write to the Chief Justice. When the Chief Justice receives that petition, he will check whether me beating my wife, for whatever reason,
It's stated misbehavior.
is stated misbehavior, and it even affects or impairs my ability to be a judge. If he establishes that, then he will set up a committee for me to come and defend myself. Now, that committee's evidence against me will be that ruling against me being a woman beater.
That's right.
I have to prove to that committee that the fact that I beat my wife in the past doesn't mean that necessarily I cannot execute my function as a judge. You may disagree with this, but this is the law.
The standard is that
saying,
you are a person
because,
of high moral character and proven integrity.
But the law says that she may only. So there is only one procedure. You cannot imply any other procedure.
Okay.
So you may have a very solid ground for thinking that she cannot be a judge. But the law says that you cannot use that procedure of removing a chief justice, which is for the six.
Okay.
To remove a judge, which is for
let me ask
the
you this, and I move on to Roxanne, hold on.
So what I think anybody should do, should do now is to simply, like they did for this one, get one of their guys again to write a petition against the woman and take it to the president.
Okay.
Then the president will refer it to the chief justice. Then the chief justice say, Madam, you know you are no longer the chief justice, but people are saying you can no longer be a judge. According to the Constitution, 1464, come and defend yourself.
Please.
Then the chief justice will form a committee.
So the new chief justice.
Yes,
okay.
Because that is the only way you can remove a judge of the Supreme Court.
Please.
You cannot use 6 to remove
so
4.
that at her time there should be a petition sent to her to make a prima facie on herself.
No. The chief justice has now been removed. That is established. He's now been removed.
Okay.
That's why I'm saying that he's been removed as the chief justice.
Hold on. Don't worry. Allow him.
He's been removed as a chief justice, which was a function.
Okay.
Remember, it was a function.
The last question I'm going to ask you. Let me put it to Theo Champong. Dr. Theo Champong.
I thought you asked me
Hold on. Dr. Theo Champong. I don't know if you share Dennis's view, but even if you don't, what do you make of the Supreme Court in at least 3 different decisions, even though those pronouncements are not what we call the star decisis that decides the case? You see that prima facie for a Chief Justice is actually not in the Constitution. It is the Supreme Court that made a decision and said the same way that if you are removing any judge or a judge of the Superior Court, you get the CJ to make a prima facie. If you want to remove the Chief Justice, you must also do a prima facie. It's not in the Constitution. The Supreme Court said it, and now it has become part of our law. This same Supreme Court, on 3 different occasions, has made pronouncements which we can say are not law. But they say that if a Chief Justice is removed, they are equally removed as a Justice of the Superior Court. Do you think it's as straight as this one?
Yeah, so fundamentally, the point that I have been asking myself, right, is does the Constitution treat the Chief Justice and then the Justice of the Supreme Court as distinct constitutional roles with separate sort of appointment routes? And if that were the case, then in other words, does the removal of a Chief Justice then automatically also remove her as a justice of the Supreme Court? Because that's the core and the argument that Justice Torkornoo really, right, is making. And my view, or sort of what she's arguing, right, is that these are very 2 distinct roles. And when you look at the constitutional provisions that others have cited, the processes for the removal are slightly different. But the grounds for removal is pretty much the same. So in my view, the starting point is 1461, right? And the 1461 which you read, which I luckily have my old copy here as well, says that a justice of the Superior Court or a chairman of a regional tribunal shall not be removed from office except on those 3 grounds which you read: stated misbehavior, incompetence, or grounds of inability to perform due to infirmity of body or mind. Then the 1462 all the way to 1466 really gives the process for the removal. So for me, the point that I argue my position on is the first 1461, the beginning point, a justice of the Superior Court. Is the Chief Justice a justice of the Superior Court? Yes. Was she removed on any of these 3 grounds: stated misbehavior, incompetence, or inability to perform? And we know that per the report that was issued, she has been removed on the grounds of stated misbehavior. And it's quite clear I'm no lawyer, but just reading this and applying sort of logic to all of this, once she has been removed as the Chief Justice, automatically she loses her position as a Justice of the Supreme Court on the grounds of the stated behavior or incompetence or any of the other things that have been mentioned. So I don't want to beat about the bush. The starting point, which is very clear to me, is 1461. The 1462 and all the other processes around that to 6 is really in terms of the process by which you go about doing, right, that removal. And if she has been removed on the basis of stated misbehavior, and it says in the 1461, a justice of the Superior Court, then I struggle to see personally, how we could sort of argue that the two are distinct roles. But again, she has the right to go to court. And this going to court or even taking it up in other sort of separate legal processes can only help improve our jurisprudence, right? We are debating this. If she goes and the court rules in a separate way, that becomes a settled law. But as far as I have read this constitution, especially on the 1461 and the grounds for removal, that clearly says that a justice of the Superior Court, and the Chief Justice is a justice of the Superior Court. In this case here, it's a bit of a, for me, moot point to sort of argue that the two are slightly distinct, and therefore she cannot be removed. Once she's been removed as a justice, as a Chief Justice, then she should still stay as a justice of the Supreme Court. I mean, even put the legalities aside, but in terms of even the optics, right? How do you then still go back to the court, engage with your other colleagues and all of that? It doesn't really kind of come across right.
Thank you very much. Do you still want to say something? Hold on. Please hold on. So as Roxanne referred to the 3 cases, in 1996, in the Justice Saban case, Justice Pega said that the removal of the Chief Justice as a fallout, a judge of the Supreme Court, the substratum of the plaintiff case was that as we have stated earlier, is that the second defendant is not a man of high moral character and proving integrity to be the Chief Justice. Ipso facto, a judge of the Supreme Court, since the qualifications are admittedly the same, if the second defendant is disqualified from occupying the post of Chief Justice on grounds of lack of integrity, I do not see how he can continue to be a judge of the Supreme Court. And then in 2006, 2005, Modibo Okran in that other case says, with no such gap filling, one is left only with Article 146, Clause 1. And since the removal of the Chief Justice of Ghana from office is pegged to the same set of grounds as any other Superior Court judge, the Chief Justice, upon removal, will by implication also lose his position as a judge, unfortunate as it may be.
Yes, Sam, this matter actually came up in the Ajaychum case. There was an issue. And the court determined that issue. So here's what Justice Databan said. Are the administrative acts of the Chief Justice immune from the impeachment process? The next declaration, so I want to read. I won't say anything. I just want to read what he wrote quickly.
Yeah.
The next declaration whose grant or refusal I will consider is the first one sought by the plaintiff. It will be recalled that the declaration sought is in the following terms. A declaration that the petition dated 13th January 2006 presented by Mr. Brian Akote to the President, which relates to the removal of the Chief Justice, is in respect of the performance of administrative functions of the CJ within the meaning of Article 1254 of the Constitution, and is therefore inconsistent with the said article. Then he went on, but this is where he exploded. He exploded this way. He said, I think that the plaintiffs, or let me give this argument. Further in paragraph 8, he sums out the essence of his argument as follows. The exercise of administrative powers by the Chief Justice, such as the transfer of enforcement of discipline among judges, enjoys complete autonomy and freedom from interference by the executive and parliament. The effect of the President's appointment of Committee 2 in essence question or inquire into the exercise of those administrative powers by the Chief Justice is to violate clear constitutional dictates and can properly be regarded as a breach of Article 1271 and 2. It undermines the authority conferred on the Chief Justice by Article 1254 as Chief Executive of the Judiciary responsible for administration and supervision of the judiciary. Surely, transfers and dismissals of judges by the Chief Justice cannot be considered acts of misbehavior or corruption. Assuming, arguing though, that the 3 judges named in the petition have genuine grievances, it will be proper for them to seek relief on their own. The proper course should be to commence an action in the courts for a declaration that their transfer or dismissal, as the case may be, is wrong in law. So that the bar exploded this way. I think that the plaintiff's argument on this issue is founded on the fallacy that a Chief Justice's conduct in the administration of the judiciary can never be construed as stated misbehavior or incompetence within the meaning of Article 146 of the Constitution. Other justices of the Superior Court also have administrative responsibilities, such as the supervising High Court judges or judges representing the judiciary or the General Legal Counsel. I believe that it will be dangerous and not in the public interest to uphold a proposition in relation to all such judges that the administrative acts cannot ever be the substance of a charge of stated misbehavior within the meaning of 1261. As far as the Chief Justice is concerned, I think it is reasonable to link his conduct of his administrative responsibilities with his position as Justice of all the Superior Courts. Justices of all the Superior Courts are required to adhere by certain judicial ethics, which can be infringed by the conduct of a Chief Justice in the performance of administrative acts. It is therefore unacceptable to exclude a priori all administrative acts of the Chief Justice from scrutiny as possible evidence of stated misbehavior in his capacity as Justice of the Superior Court. So finally, he had this to say. Moreover, the fact that it is the President who establishes the committee under Article 146 to investigate all allegations that the Chief Justice has been guilty of such as malfeasance of his administrative responsibilities as to bring him within the meaning of stated misbehavior under 146(1) does not necessarily imply executive interference in the affairs of the judiciary. I accordingly find merit in the counter-arguments of the second defendant. So clearly, when the argument is, they are making the argument as though the Chief Justice...
You said you only read and it will be enough.
Yes, the Chief Justice is decouplable from his role as a Justice of the Superior Court.
Okay,
and
so Dennis, the final comment in a minute that you are going to make it on the back of this question by Kofi. He's asking a question. If the petitioner's relief was for the removal of Gertrude Torkornoo as a Justice of the Superior Court, what would have been the procedure? If that relief were to have been granted, could she have remained CJ on grounds of constitutional procedural variations? If it was to remove her as a judge and she got removed, would she stay as a Chief Justice?
So you see, you have to be a Superior Court judge before you can be a Chief Justice. I did that logic in Legon. It's very simple. You cannot be a Chief Justice if you are not a Superior Court judge. But you can be a Supreme Court judge without being a Chief Justice.
That one, I don't even know if it's a fact.
No.
The President cannot appoint the Chief Justice from outside.
I hear you can be appointed a lawyer. I hear you can be appointed from a lawyer. But the argument still says. The argument still means that you don't have to be.
But automatically you become a judge.
I'm only helping you.
It's okay. Yes.
Don't help me. I am saying that you have to be a Supreme Court judge or come from somewhere before you can be a Chief Justice.
Therefore.
But you can be a judge, a Supreme Court judge, without being a Chief Justice. So that answer is quite clear. The point we are making is that the framers of the law are clear. They are saying that if you want to remove a judge of the Superior Court, this is the process. If you want to remove a Chief Justice, this is the process. Now, this is where the difference is. There is a clear distinction between the composition of the committee that removes a Chief Justice and the composition of the committee that removes a judge of the Superior Court. And it makes a difference.
Which is just to avoid conflict.
It is not just. There is a reason why if I go to the High Court and a judge rules against me, I go to the Appeal Court. There is even a reason why, even at the Superior Court, they can rule against me in a matter. But I will appeal, they will bring one more judge and I'll win. So there is a big difference. It is not just.
You are confused.
It is not just. I am not. There's a big difference.
The
you see, when you look at, don't do this. Don't do this. Don't do this.
No.
When you look at the composition, when you look at the composition of the committees that remove a CJ and a judge, is different. The president must appoint certain people. I think for the Chief Justice, the president must have 2 Supreme Court judges and 3 non-judges. For the judge of the Supreme Court, please. But when it comes to the removal of the judge of the Superior Court, the Supreme Court judges must be 3. Do you know what it means? What it means is that you give me the opportunity to go and face the committee that has a responsibility to now remove me as a judge. Because I can be a judge without being a Chief Justice.
Interesting.
I have been removed as a Chief Justice, but I come to you. And I'm telling you that in spite of this established case against me, it doesn't incapacitate me from playing my duties or playing my role as a judge, because the issues based on which I'm being removed as a Chief Justice were pure administrative issues. They were pure administrative issues that came about simply because I was a Chief Justice and not because I had a challenge in the application of the law as a judge.
Thank you. Yes, Clara. Yes, Clara. Let Clara end with us. Yes. So this is where, after Clara, the show is over. We are unable to move to the Imani Paul's report about dissipating goodwill for the NDC.
It's gone. It's level 2%.
There's
level 2%.
Yes.
You have done the analysis.
Yes. What specifically do you want me to address?
Whether you have anything else to say about the removal process.
No, for the removal process, no, I don't have anything to say. Like I said, the procedure is pretty simple. And once the person is occupying the role as CJ, I mean, it's just common sense. You have to, whatever accusation you make against them, you have to use the procedure provided for CJ. So I won't split heads. I don't have any other views.
So, like Sophia Kufu said in one of her interviews, this is de minimis.
Yes.
The law does not.
Yes, de minimis non curas lex. Yes.
Oh, the CJ has, formidable lawyers herself.
No, for me, I like what the CJ is doing. For my person, I like what the CJ is doing. I like anybody who fights for their rights. And that's what the CJ is doing.
Okay.
So whichever way she believes in it, I would applaud and respect the CJ for going all out. One, because I respect people who stand up for themselves. And then 2, because it also helps us to build our democracy. For being in court, I am with the Chief Justice on that one. I support her being in court.
Okay. Kingsley said, whichever way you are removed as a Superior Court judge, period. He says that Dennis is deconstructing the Constitution wrongly. The Chief Justice was first a Superior Court judge before a CJ. The procedure to remove her as a CJ is different from Superior Court judge. Theo Champon's explanation is superior. He has explained it properly. So thanks to Theo Champon. And then on the matters of Galamsey, I couldn't read any comment, but I'll read this very one comment. It says, why are we, this from George, says, why are we equating state of emergency with abuse of human rights? They shouldn't make the logical error of conflating possibility with certainty. Non-derogable rights don't extinguish under SOE. Certain rights may not automatically be suspended. The SOE is state of emergency. Certain rights may not automatically be suspended. The right to life, freedom from torture, slavery, recognition before the law, and freedom of thought, conscience, and religion. It is only when the state derogates from these that breaches occur. We've got to be blunt now. The one thing that a coup maker can exploit is the legitimate public concern and anger against the environmental suicide we are committing. If an adventurous rises citing Galamsey, our government will fall and there will be no human rights. They say war is an acronym for waive all rights. Okay, so we should do the state of emergency now. Clara Berry, thank you so very much. Dr. Theo Champon, Dennis Miracles Abuaje and Roxanne Nelson Dafiamapo. I'm Samson Ladia Yenini. Thank you. My outfit, as always, is by Konati Clothing 0244676732. Have a good afternoon.